let's move on to the proposed Solicitors Act reforms. I mean, to some extent, it comes back to what I asked earlier, that sweeping away all these formalities and interim statute bills and all the rest of it, and putting them in and leaving it to the SRA. We'll come to your bit of it in a moment. Putting it into the SRA, into professional conduct rules, because the courts clearly don't want this darkening their doors. And I suppose we kind of have to link it then to claims up to £50,000 going to the Ombudsman, which is clearly they've got there directly from the Master of the Rolls comments in Belstone.
Excuse me.
Is that going to put you out of business? Is he going to put you out of business?
Absolutely not. No. I mean, I think there's actually a lot of quite good stuff in the consultation. I think the practicalities of it are something else entirely. But the main sort of headline, from what I can see, is an overarching principle that the fees of solicitors, barristers, cross lawyers, everyone who's able to deliver services under the Legal Services Act should be fair and reasonable. And that's actually a really effective starting point. My concern would be, the suggestion is that there can be some sort of rules-based description of what fair and reasonable looks like. My concern would be that we're going to end up with a definition that's like proportionality, and no one still knows what proportionality looks like. So it could just create more and more uncertainty. But as a sort of general starting point, I think that's a fantastic idea. And what's being suggested is that there will be a view of the fairness and reasonableness of the agreement, which is potentially a new element that certainly the courts have been unwilling to look at in the context of Solicitors Act cases, but also the fairness and reasonableness of the charges. So I think there are potentially good developments there, but practicalities may be something that.
The principle, before we get to the practicality of whether the SRA or Ombudsman could deal with this, in principle, I mean, it's always struck me as someone who writes about cost a lot of this nonsense of defining whether you've got a bill in the first place before you even get to to looking at the numbers.
Well, yeah, absolutely, and I know that Mark will have a view on this, but I can't think what I'm trying to say. The contentious business agreement or non-contentious business agreement, the definition between the two. I mean, who knows from the client's perspective? How do they know which is which and what the difference is and what the rights are? And
what the third type of agreement that no one can decide to identify.
Exactly, and why do they need to? I mean, at the end of the day, as you say, they just want to know they've been charged a fair price for a good job. I have my fears, and as I've expressed before, with it going to SRA and Legal Ombudsman, is the consistency of approach across the board in these decisions. I mean, I know arguably you can say the same in terms of the district, county courts and what have you, but ultimately most cost disputes would end up in, certainly solicitor client cost disputes would end up in the SCCO, so there is an element of some consistency across the board. But that would be my concern. And capacity, the capacity issue is still the same. Whether it be SRA, Legal Ombudsman or the courts, there's a capacity issue. We need to do something to get the whole process right in the first place, which is perhaps a bit of a utopia. My concern about the fairness and reasonableness test, as outlined in the Solicitors Act consultation at this moment in time, is that what is being proposed would apply a hindsight test, because a lot of the parameters wouldn't be known at the time of signing up to your contract with your client, with your law firm. So how many documents are being considered, for example, or would require so much upfront analysis from a solicitor before they sign the contract that there'd have to be a separate pre-contract agreement for that investigation to be able to provide a quote. And then on the basis that funding isn't recoverable between the parties as well, that then comes back on the client's door. So we'll come to that.
So you see, really, Victoria, what I think the new proposal might end up doing is moving us back to the days before really there were any specific retainer agreements, because you're absolutely right. What the proposal is saying is that you look at the 7 pillars that we all the cost people know about. So the importance of the matter, the value, all of these things that you don't actually know until the case is at an end. And if that's going to form the substantial part of the test, what it's actually going to end up with is an assessment as if there had been no agreement in the first place. Because if you're saying to the client, I'm going to charge £500 an hour, but it turns out to be a case of modest value, does that then end up with an assessment, whether it's by the Ombudsman or by the court, saying, well, actually, I know you agreed 500, but in hindsight, given how this case actually turned out, it doesn't merit it.
So do you think we should go for more alternative pricing structures away from the hourly rate, more fixed fees?
I'm all for fair and reasonable.
Okay, I wonder why.
I don't want to put you on the spot, Simon, because
why change that?
well, I'm aware that Leo hasn't formally responded yet to the consultation, but there's an obvious, and they recognise it in the consultation, but there's an obvious capacity issue that not that obviously you can't speak for the SRA, but for the SRA and for yourselves, that if you were suddenly flooded with cases that would otherwise be going to court, well, I don't think we've got any idea of the kind of volume that could be, but I think we can probably say it would be quite a lot, given, and you're an organisation that takes like 10,000 or complaints a year, and given the issues that the Ombudsman has at the moment, which are well rehearsed.
I'm waiting for the question.
And bear in mind the extended time limits that are suggested. So clients would be able to go to the Ombudsman at any point, after, as I understand it, for a year after the bill's been delivered.
Yeah.
So does this have any legs at all? I mean, could you deal with this?
I mean, you started it by saying we haven't responded to the consultation, so I will say that we really need to give this some proper consideration. I'll try and be more helpful than that. There is a massive capacity issue for us, obviously. I mean, and to be clear, I hope you both think capacity in the sense of operational capacity. I think that's really good to get on tape.
You have a sizable and growing backlog of cases that you can't deal with at the moment.
Right. No, and so I mean, and there would. I don't think I'm speaking out of school here by saying who would do the work. You know, that's a legitimate question, and whether our existing knowledge base would be sufficient and adequate to reflect the complexity and challenges that this new work would bring in. The fair and reasonable question is very interesting. From a personal sort of flick-through point of view, I'm not sure whether the fair and reasonable test that's in that consultation is the same as our fair and reasonable test from our scheme rules.
Oh, right, okay.
So I'm not sure whether those two, and at least it doesn't talk about our test in that way. So I'm not sure about the alignment of that.
Because they seem to think it's aligned.
So, certainly in the broad sense of we will look at what's fair and reasonable. Of course, the courts have done that for years, isn't it? Master Cigar's Gemma Trust case. These are things where the fair and reasonable jurisdiction on costs has been explored and applied. So there is some scope for that alignment, but yeah, I mean, we don't have the people or the skill set, and I'm not sure who's paying for it because that's not mentioned in the consultation. The adequate funding. So I don't know what that will mean. There's a lot for us to look into, obviously, and we will respond to the consultation for sure.
With your ACL hat on, you could just employ a whole load of cost lawyers.
Indeed. Well, we have had that conversation, haven't we?
You've offered a load on loan, haven't you?
Well, not quite. But basically,
is it loan with an option?
No, just that the cost lawyer, the Association of Cost Lawyers, could work more closely with the Legal Ombudsman, and there's obviously a quest to get the cost lawyers to be appointed judges as well. So it might be another way around there. And of course, Mark's now joined as a trainee cost lawyer after all these years. Yeah.
Excellent. How's it like being a trainee?
It's fantastic. I would just say in relation to the point about about cost lawyers being involved in the assessment, if we're still going to call it that, by the Legal Ombudsman. Victoria will correct me if this is wrong, but my suspicion is that still the vast majority of costs lawyers predominantly work for solicitors. So I'm not certain that that could be achieved without there being at least a perception that they may not be entirely impartial.
Well, I wouldn't necessarily go to...
Other than myself.
I wouldn't
I'd do it.
and indeed myself, but I wouldn't necessarily go to the impartiality because we often act for both sides. It's an awareness of the position that the consumer finds themselves in. I think there's a lack of expertise in our profession for understanding their position from a consumer's perspective. And there's a lack of appetite to understand it as well to a certain extent. It's definitely an area of law that isn't embraced because it is inherently more complicated than doing an inter partes bill of costs and recovery working between two professionals. It's a much more difficult area. For me, very rewarding, makes you understand using your skill set and using it in a way to achieve good. And for both sides of the fence, because it isn't always the case, as you rightly pointed out, it isn't always the case that the solicitors have got it wrong and they're bad and the client is an innocent. I mean, often the consumers are far more savvy than the lawyers in terms of the cost advice. But it's about achieving the fairness for both and having that knowledge and awareness, and there's definitely a lack of expertise across our profession.
So if you were drafting the consultation instead about the future of, more broadly, this whole system, which has been, worked well for you in a negative way, what would it look like? How would law firms bill and provide estimates and get consent in your ideal world?
I think billing needs to be standardised, and in the other judgment that I don't speak of, Caritish, the Court of Appeal gave guidance as to what it expected to be in statutory bills from that point onwards, and that's been ignored to a large extent. And it's right that a lot of the arguments that happen in preliminary stages of these things are about whether or not we've put a statutory bill, and that's not just sort of it's not an empty sort of intellectual argument. The client needs to understand absolutely everything that they've been billed for, what the total bill is, and how it's made up before they can decide whether to dispute it or not. So I think the process of billing needs to be standardised, perhaps by conduct rules. I can see a lot of merit in what the consultation says about moving some of the archaic bits of the Act into conduct rules. I mean, it's how the account rules arise. They are delegated to the Law Society and then the SRA under Section 30 something of the Solicitors Act, and have been for years. So that's fine. Rules in relation to what bills look like. Rules in relation to when a bill is delivered. I mean, I was slightly concerned to see in the consultation paper that there's still reference to interim bills and final bills, which is another recipe for lack of clarity. And then the process of determination by someone other than the court, I see no particular problem with that other than the practical considerations of how it's going to be dealt with. But I think one of the really big things that's been absolutely missed is that the main barrier to getting these disputes resolved quickly, and by resolved I mean either me telling my client you've got no case whatsoever, or demonstrating to the solicitors that there is a problem, is the lack of a disclosure process in Solicitors Act proceedings. So thousands upon thousands of pounds of costs will be incurred unless I've got a sensible opponent before I get to see anything in the way of papers. There's still a resistance to sending me a copy of the retainer. But more fundamentally than that, if a case that I'm dealing with at the moment concerns whether or not clients were told that the case had gone significantly over cost budget, it's going to require analysis of thousands of pages of emails. If the solicitor's told the client, my advice to the client will be, well, got no case. But I can't get there, can't see the papers, there's no disclosure process. This is a sort of, there's no basis in law for it because we established in the Edwards and Slater and Gordon case on appeal that Part 31 applies to Solicitors Act cases. There's a reluctance on the part of many of the cost judges to divert from the standard practice that's been adopted over the last 20, 30 years to just have an inspection of the bundle of papers. But that's not the modern world. You know, a disclosure process that protected the lien that the solicitors are entitled to hold over the papers, but enabled the client, or me on behalf of the client, or Victoria or someone else, to analyse properly and reach an early conclusion as to whether actually there's something to fight about, would resolve lots of these cases at an early stage. And I think that should be a fundamental part of the new process, whether it's the bit that's dealt with by you as the Ombudsman, or whether it's the bit that's dealt with by the court. Because if a case comes to you at the Ombudsman, and let's assume that the figures are going to be less than 50,000 payments, you could have if it comes to you with both parties having been able to read and analyse the file of papers and come with a focused headline list of points for you to reach decisions on, that enables you to fulfil your task quickly, and everyone gets a reasonable opportunity to argue their case with access to all of the papers, which is one of the things that clients really don't get at the moment.
So how do you get the papers in the end?
Often we don't. Often we have to attend for a physical inspection of the file of papers at the solicitor's offices, which in a big case is absolutely impossible. And it also,
so your example that the one that you spoke to me about how many minutes you'd have for each document.
Yeah. So 100,000 page bundle of documents. So it's the entire file. 3 days allowed for inspection. We would have to get through, I think it was 55 pages per minute, read them, analyse them, take notes, because we weren't entitled to take copies of the documents away, it's physical inspection only. And then the difficulty is that we then do our points of dispute, our objections to the bill, based on notes that we may have taken 2 weeks earlier, which are only a partial record of what's actually on the file. Solicitors then have full access to the full 100,000 pages and can do all the searches and everything and rebut any points that they want to, with full access to the papers. Now, by the time we get to a hearing, we might be a year down the line. We're arguing our points having not seen the papers for a year and only having snapshot notes that we were able to take in a brief period of inspecting the papers, which produces an unfair process.
But isn't that arguably relatively easily overcome?
Absolutely.
If they follow the guide to a good cost practice and have all the cost information in one place and just send you that?
Yeah.
I mean, obviously, ideally, seeing the full file of papers would be ideal, but that would be a starting point, wouldn't it?
Or if solicitors recognise that as the High Court has found, Part 31 disclosure applies,
Yes, yeah.
disclose the papers.
Yeah.
The concern is, well, there are two concerns. There's a concern that's expressed, which is you're not entitled to these because we've got a lien and we can hold on to them. That's fine. But if, rather than us issuing proceedings under the Solicitors Act to dispute this bill, you were to sue us for the bill, then there's no question whatsoever that in that Part 7 debt claim, there'd be an order for standard disclosure, and you've got to disclose the file of papers anyway. So let's just be sensible about these things and assist the court by dealing with disclosure on a sensible basis. It's transparent. If it justifies your bill, fine. I'll tell the client it justifies the bill and we'll go away. But actually, I think the reason that disclosure is resisted is because solicitors are concerned about close scrutiny, because they may not have updated the client properly with cost information quite as regularly as they should have done. But if that's the case, let's deal with it.
I think Part 30, again, this is my ignorance, Part 31 applies, why can't you just make an application?
Because there is a resistance on the part of the cost judges to order disclosure, because a practice has grown up over the last, I suppose, 30 or 40 years of only allowing inspection. I suppose because if we go back 30 years, providing electronic copies of documents was an impossibility. So really the only way to go about this, other than sending an entire pile of papers to a photocopier, was to go and physically inspect. And although the appeal case in Edward and Slade and Gordon was quite clear, and although the Court of Appeal said when Slade and Gordon tried to take it for a second appeal, well, of course Part 31 applies to these cases, there is still a reluctance on the part of the cost judges to order standard disclosure, because
you're not afraid to take a case. Why can't you just take one to show them up and force them to change?
we may well be doing that.
Right, okay.
Watch this space.